Hello and welcome back to our channel. Today we are diving deep into the significant changes coming to UK immigration in 2025. These updates represent a major shift in how the UK handles immigration processes, particularly for EU nationals, and introduce important fee changes that affect both individuals and employers. Before we delve into the details, be sure to subscribe to our channel and hit the bell icon for upcoming updates. Now, let's get started. One of the most significant developments for 2025 is the automation of the EU Settlement Scheme, EUSS, transitions. Starting January 2025, the Home Office is implementing an automated system for converting pre-settled status to settled status for eligible European nationals. This groundbreaking change means many EU citizens won't need to manually apply for settled status anymore, a major streamlining of the current process. The automation will work by accessing government-held records, particularly national insurance contributions, to verify eligibility automatically. However, it's crucial to understand that this isn't a universal solution. Those without accessible records or with complicated circumstances, such as criminal records or gaps in residency evidence, may still need to go through the manual application process. Looking at the financial aspects, 2025 brings significant increases in visa-related fees. The certificate of sponsorship fee has more than doubled, jumping from £239 to £525 for general workers. Temporary worker sponsorship certificates have also seen an increase, rising from £25 to £55. These increases represent a substantial additional cost for employers sponsoring foreign workers. Another notable change is the increase in electronic travel authorization, ETA, fees, rising from £10 to £16. This change affects visitors to the UK and reflects the government's broader strategy of making the immigration system more self-funding rather than relying on taxpayer support. A crucial update for employers concerns clawback arrangements. New Home Office guidance has made it explicitly unlawful for visa applicants to bear the cost of sponsorship-related expenses. This prohibition extends beyond basic visa fees to include priority processing charges and any associated sponsorship costs. Employers must ensure their clawback agreements comply with these new regulations, necessitating a review and possible revision of existing policies. These changes require organizations to carefully reconsider their recruitment and retention strategies. The increased sponsorship costs, combined with the prohibition on passing these costs to employees, mean businesses need to review their budgets and policies carefully. This is particularly challenging for small and medium-sized enterprises, who may need to reassess their approach to international recruitment in light of these higher costs. The automated EUSS transition system represents a significant technological advancement in immigration processing. This innovative approach aims to reduce the administrative burden on both applicants and the Home Office, potentially processing thousands of cases more efficiently. The system will be particularly beneficial for those with clear, documented UK residency histories, though it's crucial for all EU nationals to maintain comprehensive records of their UK residence. For EU nationals currently holding pre-settled status, the automation brings welcome relief from the active application requirement for settled status. However, it remains crucial for these individuals to ensure their UK residence is properly documented through various official records, including national insurance contributions, council tax bills, and other relevant documentation. This becomes especially important if the automated system encounters difficulties verifying eligibility. Employers must pay particular attention to the new guidelines on clawback arrangements. Existing agreements need careful review and potential revision to ensure compliance with the new regulations. Any provisions for recovering sponsorship-related costs from employees must be removed or updated to reflect the new requirements, ensuring organizations remain compliant with immigration law. The ETA fee increase is part of a comprehensive strategy to modernize the UK's border security and immigration system. This digital authorization will become mandatory for an increasing number of visitors, creating a more robust pre-travel screening system. The change reflects the UK's commitment to enhancing border security while maintaining efficiency in processing legitimate travel. Looking to the future, these changes indicate a continued evolution of the UK's immigration system towards greater automation and digital processing. While this should ultimately lead to more efficient processes, the transition period may present challenges that both individuals and organisations need to prepare for. For employers, these changes necessitate careful planning around higher sponsorship costs, ensuring compliance with new clawback regulations, and potentially developing alternative strategies for international recruitment. Some organizations may need to focus more on domestic recruitment or explore different approaches to talent acquisition and development. EU nationals should maintain detailed records and monitor their status transition carefully, even with the automated system in place. Those with complex cases or unusual circumstances should seek professional advice to ensure they navigate the system successfully and maintain their immigration status. The increased fees and automation reflect the UK's efforts to balance efficient immigration processing with proper controls and sustainable funding. While the higher costs may present challenges, the automation promises to reduce processing times and administrative burdens for many applicants. Stay connected with our channel for continuous updates as these changes roll out. We'll be monitoring the implementation of the automated EUSS system closely and providing guidance on navigating the new fee structures and compliance requirements. Our commitment is to keep you informed about these important immigration changes and their practical implications. These changes, while presenting new challenges, also offer opportunities for more efficient and streamlined immigration processes. Understanding and preparing for these changes now will help ensure a smoother transition when they take effect in 2025. Whether you're an employer, EU national, or other stakeholder in the UK immigration system, staying informed and prepared is key to successfully navigating these new requirements. If you find yourself affected by these changes, we recommend taking several proactive steps. First, review your timelines and budgets for any planned applications to account for the new fees. Second, consider seeking professional advice if you're unsure of how these changes impact your specific situation. Finally, stay informed about implementation dates and any potential modifications to the proposed increases to avoid any last-minute surprises. As we wrap up our discussion, remember to subscribe to our channel for the latest updates on UK immigration policies and fee changes. We will continue to cover new developments as they arise and provide detailed analyses of their implications. If you have questions about how these changes may affect you or your organization, feel free to drop them in the comments below. We will do our best to address them in future videos. Thank you for watching, and we look forward to seeing you in the next video.